committing a felony or deleto, although the wrongful act done be different from that which he intended. By any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Application of Article 4. Criminal liability is incurred by any person in the cases mentioned in the two paragraphs of Article 4. This article has no reference to the manner criminal liability is incurred. The manner of incurring criminal liability under the RPC is stated in Article 3. That is performing or failing to do an act when either is punished by law by means of deceit with malice or fault through negligence or imprudence. One who commits an intentional felony is responsible for all the consequences which may naturally and logically result therefrom, whether foreseen or intended or not. Ordinarily, when a person commits a felony with malice, he intends the consequences of his felonious act, but there are cases where the consequences of the felonious act of the offender are not intended by him. In those cases, the wrongful act done is different from that which he intended. In view of paragraph 1 of Article 4, a person committing a felony is criminally liable, although the consequences of his felonious act are not intended by him. There is no question that the death of the victim was brought about by the rape committed by the accused. Her death was due to profuse hemorrhage brought about by the laceration of the vagina caused by a stiffened male organ or by the insertion of a hard blunt object. That the accused did not intend to kill her was of no moment. A person who performs a criminal act is responsible for all the consequences of said act regardless of his intention. People versus Mariano. One is not relieved from criminal liability for the natural consequences of one's illegal acts merely because one does not intend to produce such consequences. U.S. versus Brobst. Thus, one who fired his gun at B but missed and hit C instead is liable for the injury caused to C, although the one who fired the gun had no intention to injure C. One who gave a fist blow on the head of D, causing the latter to fall with the latter's head striking a hard pavement, is liable for the death of D, which resulted although the one who gave the fist blow had no intention to kill D. And one who stabbed another in the dark, believing that the latter was E, when in fact he was G, is liable for the injury caused to G, although the one who stabbed him had no intention to injure G. Rationale of rule in paragraph 1 of Article 4. The rationale of the rule in Article 4 is found in the doctrine that el que es causa de la causa es causa del mal causado. He who is the cause of the cause is the cause of the evil cause. People versus Urat. March 27, 1974. Important words and phrases in paragraph 1 of Article 4. Committing a felony, paragraph 1 of Article 4 says that criminal liability shall be incurred by any person committing a felony, not merely performing an act. A felony is an act or omission punishable by the RPC. If the act is not punishable by the code, it is not a felony. But the felony committed by the offender should be one committed by means of dolo. That is with malice, because paragraph 1 of Article 4 speaks of wrongful act done different from that which he intended. If the wrongful act results from the imprudence, negligence, lack of foresight, or lack of skill of the offender, his liability should be determined under Article 365, which defines and penalizes criminal negligence. The act or omission should not be punished by a special law because the offender violating a special law may not have the intent to do an injury to another. In such case, the wrongful act done could not be different as the offender did not intend to do any other injury. Article 4, paragraph 1 is not applicable in this case. Defendant who was not a regular medical practitioner tied a girl, wrapped her feet with bags saturated with petroleum, and thereafter set them on fire causing injuries. His defense was that he undertook to render medical assistance in good faith and to the best of his ability to cure her of ulcer. He admitted applying petroleum but denied causing the burns. Help. While there was no intention to cause an evil but to provide a remedy, accused was liable for injuries through imprudence. U.S. versus Divino. Note, defendant did not commit an intentional felony. If at all, he committed illegal practice of medicine, which is punished by a special law. Violation of a statute is proof of negligence or imprudence. Defendant is liable for two offenses: physical injuries through imprudence and illegal practice of medicine. When a person has not committed a felony, he is not criminally liable for the result which is not intended. Thus, one who, because of curiosity, snatched the bolo carried by the offended party at his belt, and the latter instinctively caught the blade of said bolo and tried to retain it, is not criminally liable for the physical injuries caused, because there is no provision in the RPC which punishes that act of snatching the property of another just to satisfy curiosity. U.S. versus Villanueva. Thus, also one who tries to retain the possession of his bolo which was being taken by another, and because of the struggle, the tip of the bolo struck and pierced the breast of a bystander, is not criminally liable. Therefore, because the law allows a person to use the necessary force to retain what belongs to him. People versus Bindoy. People versus Bindoy. Facts: in a tuba wine shop in the Barrio Market, the accused offered tuba to Pacas's wife, and as she refused to drink, having already done so, the accused threatened to injure her if she would not accept. There ensued an interchange of words between her and the accused, and Pacas stepped in to defend his wife, attempting to take away from the accused the bolo he carried. This occasioned a disturbance which attracted the attention of Emigdio among them who lived near the market. Emigdio left his house to see what was happening while the accused and Pacas were struggling for the bolo. In the course of this struggle, the accused succeeded in disengaging himself from Pacas, wrenching the bolo from the latter's hand towards the left behind the accused with such violence that the point of the bolo reached Emilio Mamdam's chest, who was then behind the accused. The accused was not aware of Mamdam's presence in the place. Held, there is no evidence to show that the accused injured the deceased deliberately and with the intention of committing a crime. He was only defending his possession of the bolo, which Pacas was trying to wrench away from him, and his conduct was perfectly legal. The accused should be acquitted. Had the accused attempted to wound Pacas during the struggle, but instead of doing so, he wounded Umamdam, he would have been liable for the death of Umamdam, because in attempting to wound another, the accused would be committing a felony, which is attempted homicide, if there is intent to kill under Article 249 in relation to Article 6. Although the wrongful act done be different from that which he intended, the causes which may produce a result different from that which the offender intended are mistake in the identity of the victim, mistake in the blow, that is, when the offender intending to do an injury to one person actually inflicts it on another, and the act exceeds the intent, that is, the injurious result is greater than that intended. Under paragraph 1, article 4, a person committing a felony is still criminally liable even if there is a mistake in the identity of the victim, error in persone. In a case, defendant went out of the house with the intention of assaulting Dunka, but in the darkness of the evening, defendant mistook Mapudol for Dunka and inflicted upon him a mortal wound with a bolo. In this case, the defendant is criminally liable for the death of Mapudol. People versus Gona. There is a mistake in the blow, aberratio ictus. Mistake, People versus Umawid, where Maurin's death was a cause of aberratio ictus, given that the fatal blow therefore was only delivered by mistake, as it was actually Vicente who was Umawid's intended target. Umawid was held liable for murder for the death of Maurin. The injurious result is greater than that intended, praeter intentionem. People versus Kagoko, where that intended, praeter intentionem. People versus Kagoko, where the accused, without intent to kill, struck the victim with his fist on the back part of the head from behind, causing the victim to fall down with his head hitting the asphalt pavement and resulting in the fracture of his head. It was held that the accused was liable for the death of the victim, although he had no intent to kill said victim, although the wrongful act done be different from that which he intended. Accused, People versus Mabugat. Mabugat. The accused and Juana Boralo were sweethearts. One day, the accused invited Juana to take a walk with him, but the latter refused him on account of the accused having frequently visited the house of another woman. Later on, the accused went to the house of Cirilo Bayan, where Juana had gone to take part in some devotion. There, the accused revolver in hand, waited until Juana and her niece Perfecta came downstairs. When they went in the direction of their house, the accused followed them. As the two girls were going upstairs, the accused, while standing at the foot of the stairway, fired a shot from his revolver at Juana, but which wounded Perfecta. The slug passing through a part of her neck, having entered the posterior region, thereof and coming out through the left eye. Perfecta did not die due to proper medical attention. The accused is guilty of frustrated murder qualified by treachery committed on the person of Perfecta Boralo. In People versus Tomotorgo, the conduct of the wife of the accused aroused his ire and incensed his wrath and his anger beyond control. He picked up a piece of wood and started hitting his wife with it until she fell to the ground, complaining of severe chest pains. Realizing what he had done, he picked her up in his arms and brought her home. Despite his efforts to alleviate her pains, the wife died. Prosecuted for parricide, he pleaded guilty and was allowed to establish mitigating circumstances. Passing on his contentions, the Supreme Court held that the fact that the appellant intended to maltreat his wife only or inflict physical injuries does not exempt him from liability for the resulting and more serious crime of parricide. To the same effect, People versus Monleon, where it was held that the case is covered by Article 4 of the RPC, which provides that criminal liability is incurred by any person committing a felony, although the wrongful act done be different from that which he intended, because the maltreatment inflicted by the accused on his wife was the proximate cause of her death. The accused, in his inebriated state, had no intent to kill her. He was infuriated because his son did not feed his carabao. He was provoked to castigate his wife because she prevented him from whipping his negligent son. He could have easily killed his wife had he really intended to take her life. He did not kill her outright. Requisite of paragraph 1 of Article 4. In order that a person may be held criminally liable for a felony different from that which he intended to commit, the following requisites must be present: that an intentional felony has been committed and that the wrong done to the aggrieved party be the direct, natural, and logical consequence of the felony committed by the offender. U.S. versus Brobst. That a felony has been committed. Thus, in the cases of U.S. versus Villanueva and People versus Bindoy, the accused were not held criminally liable because they were not committing a felony when they caused the injury to another. No felony is committed when the act or omission is not punishable by the RPC, or when the act is covered by any of the justifying circumstances enumerated in Article 11. An act which is not punishable by the RPC is attempting to commit suicide. Therefore, if A, in attempting a suicide, jumped out of the window to kill himself, but when he dropped to the ground, he fell on an old woman who died as a consequence, A is not criminally liable for intentional homicide. A was not committing a felony when he attempted a suicide. One who shoots at another in self-defense, defense of relative, defense of a stranger, or in the fulfillment of duty is not committing a felony, the act being justified. Article 11, Revised Penal Code. Hence, if B, who was being fired at with a gun by C to kill him, fired his pistol at the latter in self-defense but missed him and instead hit and killed D, a bystander, B is not criminally liable for the death of D. One acting in self-defense is not committing a felony. A policeman was pursuing to arrest an armed prisoner who had just escaped from jail, fired his service pistol at the latter when he refused to be captured. The slug fired from the pistol of the policeman after hitting the prisoner on his right leg hit and seriously injured a passerby. The policeman is not criminally liable for the injury caused to the passerby because being in the fulfillment of a duty, he was not committing a felony. Of course, the act of defense or fulfillment of duty must be exercised with due care, otherwise, the accused will be liable for culpable felony. People versus Belbes. Appellant Pat Belbes and Pat Pabon were assigned to maintain peace and order at the junior and senior prom of Pili Barangay High School. While the teacher in charge, Appellant and Pat Pabon, were watching the dance, two students reported to the teacher in charge that there was somebody making trouble. Appellant and Pat Pabon, armed with an Armalite rifle and 38 caliber revolver, respectively responded and moments after the two police officers left bursts of gunfire filled the air. Pataler, a graduating student at the school, was hit on the different parts of his body and died. Moments before the gruesome incident, Bataler, then drunk, was vomiting and holding on the bamboo wall of the school's temporary building when the bamboo splits broke. At that instant, Appellant and Pat Pabon appeared, and without warning, Appellant fired his gun. Appellant contends that he was only performing his official functions when he responded in the course of police duties to the information that somebody was making trouble and disturbing the peace. Being in charge of maintaining peace and order within the vicinity, he asserted the veracity of the information given by the students concerned. He asserts that in the absence of intent and voluntariness, he cannot be faulted for the death of the deceased. Appellant acted in the performance of his duty. However, the killing did not necessary consequence of the performance of his duty. His duty was to maintain peace and order during the junior and senior prom, but he exceeded such duty when he fired his Armalite without warning. Appellant is guilty of homicide. Any person who creates in another's mind an immediate sense of danger, which causes the latter to do something resulting in the latter's injuries, is liable for the resulting injuries. During a robbery in a passenger jeepney, one of the culprits told the women passenger to bring out their money and not to shout, or else there will be shots. One of the women jumped out of the jeepney. Her head struck the pavement. She died as a consequence. It was held that if a man creates in another person's mind an immediate sense of danger, it causes such person to try to escape, and in so doing, the latter injures himself. The man who creates such a state of mind is responsible for the resulting injuries. People versus Pagi. People versus Tolling. The reason for the ruling is that when the culprit demanded money from the women, threatening to shoot if they would not bring out their money, a felony was being committed. At that stage of execution, attempted robbery with intimidation, which is punishable under Article 294 in relation to Article 6 and Article 51 of the Code. The tolling case, relying on U.S. versus Valdez, quoted the syllabus thus: if a person against whom a criminal assault is directed reasonably believes himself to be in danger of death or great bodily harm, and in order to escape jumps into the water impelled by the instinct of self-preservation, the assailant is responsible for homicide in case death results by drowning. Wrong done must be the direct, natural, and logical consequence of felonious act. It is an established rule that a person is criminally responsible for acts committed by him in violation of the law and for all the natural and logical consequences resulting therefrom. U.S. versus Sornito, U.S. versus Zamora, People versus Cornell. In the following cases, the wrong done is considered the direct, natural, and logical consequence of the felony committed. Although A. The victim who was threatened or chased by the accused with a knife jumped to the water, and because of the strong current or because he did not know how to swim, he sank down and died of drowning. U.S. versus Valdez. People versus Buhay. The victim removed the drainage from the wound, which resulted in the development of peritonitis, which in turn caused his death. It appearing that the wound caused by the accused produced extreme pain and restlessness, which made the victim remove it. People versus Canson. Other causes cooperated in producing the fatal result as long as the wound inflicted is dangerous, that is calculated to destroy or endanger life. This is true even though the immediate cause of the death was erroneous or unskillful medical or surgical treatment. This rule really seems to have its foundation in a wise and practical policy. A different doctrine would tend to give immunity to crime and to take away from human life a salutary and essential safeguard. Amid the conflicting theories of medical men and the uncertainties attendant upon the treatment of bodily ailments and injuries, it would be easy in many cases of homicide to raise a doubt as to the immediate cause of death and thereby to open wide the door by which persons guilty of the highest crime might escape conviction and punishment. But where it clearly appears that the injury would not have caused death in the ordinary course of events, but would have healed in so many days, and where it is shown beyond all doubt that the death was due to the malicious or careless acts of the injured person or a third person, the accused is not liable for homicide. One is accountable only for his own acts and their natural or logical consequences, and not for those which bear no relation to the initial cause and are due, for instance, to the mistakes committed by the doctor in the surgical operation and treatment of the victim's wound. B. The victim was suffering from internal malady. Blow was efficient cause of death. The disease had a delicate constitution and was suffering from tuberculosis. The accused gave fist blows on the deceased's right hypochondrium, bruising the liver and producing internal hemorrhage, resulting in the death of the victim. The accused was liable for homicide. People versus Illustre. Blow accelerated death. The deceased was suffering from internal malady. The accused gave fist blows in the back and abdomen, producing inflammation of the spleen and peritonitis and causing death. The accused was liable for homicide because by his fist blows, he produced the cause for the acceleration of the death of the deceased. People versus Rodriguez. Blow was proximate cause of death. The deceased was suffering from heart disease. The accused stabbed the deceased with a knife, but as the blade of the knife hit a bone, it did not penetrate the thoracic cavity, but it produced shock, resulting in the death of the victim. The accused was liable for homicide because the stabbing was the proximate cause of the death of the deceased. People versus Reyes. The offended party refused to submit to surgical operation. The offended party is not obliged to submit to a surgical operation to relieve the accused from the natural and ordinary results of his crime. U.S. versus Marasigan. The resulting injury was aggravated by infection. Without the stab wounds, the victim would not have been afflicted with an infection which later on caused multiple organ failure that caused his death. Belbis versus People. The offender is criminally liable for the death of the victim if his delictual act caused, accelerated, or contributed to the death of the victim. People versus Kutura. The fact that the wounds might have been cured sooner than 58 days had the offended party not been addicted to tobacco drinking does not mitigate the liability of the accused. U.S. versus Bayutas. The accused attacked the deceased with a bolo. After the deceased had fallen, the accused threw a stone which hit him on the right clavicle. The wounds inflicted could not have caused the death of the deceased. A week later, the deceased died of tetanus secondary to the infected wound. Held, the accused is responsible for the death of the deceased. People versus Cornell. Cornell. People versus Canson. Facts: the accused took hold of a fireband and applied it to the neck of the person who was pestering him. The victim also received from the hand of the accused a wound in his abdomen below the navel. While undergoing medical treatment, the victim took out the drainage from his wound, and as a result of the peritonitis that developed, he died. The accused claimed as a defense that had not the deceased taken out of the drainage, he would not have died. Held. The death was the natural consequence of the mortal wound inflicted the victim. In removing the drainage from his wound, did not do so voluntarily, and with knowledge that it was prejudicial to his health. The act of the victim, removing the drainage from his wound, was attributed to his pathological condition and state of nervousness and restlessness on account of physical pain caused by the wound, aggravated by the contact of the drainage tube with the inflamed peritoneum. U.S. versus Marasiga. Facts: the accused drew his knife and struck at Mendoza in attempting to ward off the blow. Mendoza was cut in the left hand. The extensor tendon in one of the fingers was severed. As a result, the middle finger of the left hand was rendered useless. Held. Nor do we attach any importance to the contention of the accused that the original condition of the finger could be restored by a surgical operation. Mendoza is not obliged to submit to a surgical operation to relieve the accused from the natural and ordinary results of his crime. It was his voluntary act which disabled Mendoza, and he must abide by the consequences resulting therefrom without aid from Mendoza. People versus Relo. The accused stabbed the victim with an ice pick. The victim was brought to the hospital where a surgical operation was performed upon him. Although the operation was successful and the victim seemed to be in the process of recovery, he developed 5 days later a paralytic ileum, which takes place sometimes in consequence of the exposure of the internal organs during the operation, and then died. held. It is contended that the immediate cause of the death of the victim was a paralysis of the ilium that supervened 5 days after the stabbing when he appeared to be on the way to full recovery. It has been established, however, that the exposure of the internal organs in consequence of a surgical operation in the abdomen sometimes results in a paralysis of the ilium. That said operation had to be performed on account of the abdominal injury inflicted by the accused. The accused is responsible for the natural consequences of his own acts. The felony committed must be the proximate cause of the resulting injury. Proximate cause is that cause which, in natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury and without which the result would not have occurred. Bataclan versus Medina. Moreover, a person committing a felony is criminally liable for all the natural and logical consequences resulting therefrom, although the wrongful act done be different from that which he intended. Natural refers to an occurrence in the ordinary course of human life or events, while logical means that there is a rational connection between the act of the accused and the resulting injury or damage. The felony committed must be the proximate cause of the resulting injury. Proximate cause is that cause which, in natural and continuous sequence, unbroken by an efficient intervening cause, produces the injury, and without which the result would not have occurred. The proximate legal cause is that acting first and producing the injury, either immediately or by setting other events in motion, all constituting a natural and continuous chain of events, each having a close causal connection with its immediate predecessor. A felony committed must be the proximate cause of the resulting injury. Proximate cause is that cause which, in natural and continuous sequence unbroken by any efficient intervening cause, produces the injury and without which the result would not have occurred. Moreover, a person is committing a felony is criminally liable for all the natural and logical consequences resulting therefrom, although the wrongful act done be different from that which he intended. Natural refers to an occurrence in the ordinary course of human life or events, while logical means that there is a rational connection between the act of the accused and the resulting injury or damage. The felony committed must be the proximate cause of the resulting injury. Proximate cause is that cause which, in natural and continuous sequence unbroken by an efficient intervening cause, produces the injury and without which the result would not have occurred. The proximate legal cause is that acting first and producing the injury either immediately or by setting other events in motion, all constituting a natural and continuous chain of events, each having a close causal connection with its immediate predecessor. There must be a relation of cause and effect, the cause being the felonious act of the offended, the effect being the resultant injuries and or death of the victim. The cause and effect relationship is not altered or changed because of the pre-existing conditions such as the pathological condition of the victim, the predisposition of the offended party, or the concomitant or concurrent conditions such as the negligence or fault of the doctors, or the conditions supervening the felonies acts such as tetanus, pulmonary infection, or gangrene. The felony committed is not the proximate cause of the resulting injury when there is an active force that intervenes between the felony committed and the resulting injury, and the active force is a distinct act or fact absolutely foreign from the felonious act of the accused, or the resulting injury is due to the intentional act of the victim. If a person inflicts a wound with a deadly weapon in such a manner as to put life in jeopardy, and death follows as a consequence of their felonious act, it does not alter its nature or diminish its criminality to prove that other causes cooperated in producing the factual result. The offender is criminally liable for the death of the victim if his delictual act caused, accelerated, or contributed to the death of the victim. A different doctrine would tend to give immunity to crime and take away from human life a salutary and essential safeguard. Quinto versus Andres. How to determine the proximate cause. At about 2 in the morning, while the bus was running very fast on the highway, one of the front tires burst and the vehicle began to zigzag until it fell into a canal and turned turtle. Four of its passengers could not get out of the overturned bus. It appeared that as the bus overturned, gasoline began to leak from the tank on the side of the chassis, spreading over and permeating the body of the bus and the ground under and around it. About 10 men, one of them carrying a lighted torch, approached the overturned bus to help those left therein, and almost immediately a fierce fire started, burning the four passengers trapped inside it. What is the approximate cause of the death of the four passengers? The negligence of the driver, resulting in the fall into the canal and overturning of the bus, or the fire that burned the bus. It may be that ordinarily, when a passenger bus overturns and pins down a passenger, merely causing him physical injuries. If through some event unexpected and extraordinary, the overturned bus set, say by lightning, or if some highway after looting the vehicle set on fire and the passenger is burned to death, one might still contend the approximate cause of this death was the fire and not the overturning of the vehicle. But in the present case, and under the circumstances obtaining in the same, not hesitate to hold that the approximate cause of the death was the overturning of the bus. This for the reason that when the vehicle turned not only on its side but completely on its back, the leaking of the gasoline from the tank was not unnatural or unexpected. That the coming of the men with lighted torch was in response to the call for help made not only by the passengers but most probably by the driver and the conductor themselves, and that because it was very dark, the rescuers had to carry a light with them. And coming as they did from a rural area where lanterns and flashlights were not available, they had to use a torch, the most handy and available. And what was more natural than that, said rescuers should innocently approach the overturned vehicle to extend the aid and effect the rescue requested from them. In other words, the coming of the men with the torch was to be expected. and was a natural sequence of the overturning of the bus, the trapping of some of its passengers, and the call for outside help. What is more, the burning of the bus can also in part be attributed to the negligence of the carrier through its driver and its conductor. According to the witnesses, the driver and the conductor were on the road walking back and forth. They, or at least the driver, should and must have known that in the position in which the overturned bus was, gasoline could and must have leaked from the gasoline tank and soaked the area in and around the bus. This aside from the fact that gasoline, when spilled, especially over a large area, can be smelled and detected even from a distance. And yet, neither the driver nor the conductor would appear to have cautioned or taken steps to warn the rescuers not to bring the lighted torch too near the bus. That is negligence on the part of the agents of the carrier. De Bataclan et al. Versus Medina. People versus Garcia. Petitioner assaulted the victim who continued to parry petitioner's blows. Petitioner then reached for a bottle of beer and with it struck the lower back portion of the victim's head. When the victim found an opportunity to escape, he ran towards his house and phoned his wife to call the police. The victim told his wife about the mauling and complained of difficulty in breathing. Upon reaching the victim's house, the policeman knocked 5 times but nobody answered. The victim's wife arrived minutes later, unlocked the door, and found the victim lying unconscious on the kitchen floor, salivating. He was pronounced dead on arrival at the hospital. The autopsy confirmed that the victim died of myocardial infarction. Petitioner is guilty of homicide. He was committing a felony when he boxed the victim and hit him in the bottle. Hence, the fact that the victim was previously afflicted with a heart ailment does not alter petitioner's liability for his death. Ingrained in our jurisprudence, the doctrine laid down in the case of U.S. versus Brobst that where death results as a direct consequence of the use of illegal violence, the mere fact that the deceased or weakened condition of the injured person contributed to his death does not relieve the illegal aggressor of criminal responsibility. In the same vein, United States versus Rodriguez enunciates that although the assaulted party was previously affected by some internal malady, if because of a blow given with the hand or the foot, his death was hastened. Beyond peradventure, he is responsible therefore, who produced the cause for such acceleration as the result of a voluntary and unlawfully inflicted injury. In this jurisdiction, a person committing a felony is responsible for all the natural and illogical consequences resulting from it, although the unlawful act performed is different from the one he intended. In the case of People versus Martin, the accused who strangled his wife, then suffering from heart disease, was found guilty of parricide even if the death of his wife was the result of heart failure, because the heart failure was due to the fright or shock caused by the strangling, which is a felony. The following are not deficient intervening causes. The weak or diseased physical condition of the victim, as when one is suffering from tuberculosis or heart disease. People versus Illustre and People versus Reyes. The nervousness or temperament of the victim, as when a person dies in consequence of an internal hemorrhage brought on by moving about against the doctor's orders because of his nervous condition due to the wound inflicted by the accused. People versus Almonte, People versus Canson. Causes which are inherent in the victim, such as A. The victim not knowing how to swim, and B. The victim being addicted to tobacco drinking. People versus Buhay, US versus Valdez, US versus Bayutas. Neglect of the victim or third person, such as the refusal by the injured party of medical attendance or surgical operation, or the failure of the doctor to give anti-tetanus injection to the injured person. Erroneous or unskillful medical or surgical treatment, as when the accused took place in an outlying barrio where proper modern surgical service was not available. Delay in the medical treatment of the victim. Those causes not being efficient intervening causes do not break the relation of cause and effect, the felony committed and the resulting injury. People versus Piamonte et al. One of the accused stabbed the injured party with a hunting knife on October 28, 1951. The injured party was taken to the hospital and was operated on. The operation did him well, but on December 19, 1951, he contracted a sickness known as mucus colitis, which developed because of his weak condition. He died on December 28, 1951. Is the accused who stabbed the injured party liable for the latter's death. The doctors who attended the injured party agreed that his weakened condition, which caused disturbance in the functions of his intestines, made it possible for him to contract mucous colitis, which shows that while the wounds inflicted were not the immediate cause, they were, however, the proximate cause of the death. This is enough to make the accused responsible for the crime charged. Note that the charge was robbery with homicide. The homicide was committed with malice, and death is presumed to be the natural consequence of physical injuries inflicted. The death of the victim is presumed to be the natural consequence of the physical injuries inflicted when the following facts are established: that the victim at the time of the physical injuries were inflicted was in normal health, that death may be expected from the physical injuries inflicted, that death ensued within a reasonable time. People versus Datu Baginda. It having been established that the boy Juntam was in good health on the morning of the incident, that he was whipped, spanked, and thrown against the post by his teacher, his breast hitting it, that he complained to his mother about the oppressive pain, crying and massaging his breast all the time, that he was found to have two suspicious bluish spots, a big one on the breast and another one on the upper left arm, and that he vomited blood until he died 3 days afterwards. And there being no proof of any intervening cause, the liability of the teacher for homicide necessarily follows from the premises stated. People versus Tama. Had it been proved as claimed by the defense that the boy died of hydrophobia, that would have constituted an intervening cause and the accused would have been acquitted. Not direct, natural and logical consequence of the felony committed. If the consequences produced have resulted from a distinct act or fact absolutely foreign from the criminal act, the offender is not responsible for such consequences. A person is not liable criminally for all possible consequences which may immediately follow his felonious act, but only for such as are proximate. Thus, when a person struck another with his fist and knocked him down on a horse near them, jumped upon him and killed him, the assailant was not responsible for the death of that other person. People versus Rockwell. This case should be distinguished from the case of People versus Kagoko. In the Kagok case, there was no active force that intervened between the felonious act and the result. In the Rockwell case, there was an active force, the jumping of the horse upon the deceased, which produced the result. In the following cases, the injury caused is not the direct, logical, and necessary consequence of the felony committed, because the felony committed is not the proximate cause of the incident of the resulting injury. If slight physical injuries be inflicted by A upon B, and the latter deliberately immerses his body in a contaminated cesspool, thereby causing his injuries to become infected and serious, A cannot be held liable for the crime of serious physical injuries. U.S. versus De Los Santos. The act of B in deliberately immersing his body in a contaminated cesspool, not the slight physical injuries inflicted by A, is the proximate cause of the serious physical injuries. The accused struck a boy on the mouth with the back of his hand. Later, the boy died. Death might have been caused by fever prevalent in the locality, not by the blow on the mouth. The accused who gave the blow was not liable for the death of the deceased. People versus Palalon. The accused struck a child who was seriously ill with a fever for 3 weeks upon the thighs with a slipper, pushed and dragged him, throwing him heavily on the mat spread on the floor. The child died 2 days later. As the true cause of the child's death was not proved, the accused was convicted of physical injuries only. U.S. versus Embate, where medical findings lead to a distinct possibility that the infection of the wound by tetanus was an efficient intervening cause. Later, or between the time the deceased was wounded to the time of his death, the accused must be acquitted of the crime of homicide. The felony committed is not the proximate cause of the resulting injury when there is an active force that intervened between the felony committed and the resulting injury, and the active force is a distinct act or fact absolutely foreign from the felonious act of the accused, or the resulting injury is due to the intentional act of the victim. Is the accused responsible for the result if there is a neglect of the wound, or there is an improper treatment of the wound? In the case of People versus Moldes, where the accused was convicted of homicide, counsel for the accused claimed that if the deceased had secured proper surgical treatment, the wound would not have been fatal. The court held that the general rule is that he who inflicts the injury is not relieved of responsibility if the wound inflicted is dangerous. That is calculated to destroy or endanger life, even though the immediate cause of the death was erroneous or unskillful medical or surgical treatment. And the numerous cases there cited. Unskillful and improper treatment may be an active force, but it is not a distinct act or fact absolutely foreign from the criminal act. If the accused criminally liable for the consequences which originate through the fault or carelessness of the injured person, in the case of U.S. versus Monasterial, it was held that persons who are responsible for an act constituting a crime are also liable for all the consequences arising therefrom and inherent therein, other than those due to incidents entirely foreign to the act executed or which originate through the fault or carelessness of the injured person, which are exceptions to the rule not arising in the present case. In the case of People versus Kianson, it is stated that one who inflicts injury on another is deemed guilty of homicide if the injury contributes to the death of the latter, even if the deceased might have recovered if he had taken proper care of himself or submitted to surgical operation. It would seem that the fault or carelessness of the injured party, which would break the relation of the felony committed and the resulting injury, must have its origin from his malicious act or omission, as when the injured party had a desire to increase the criminal liability of his assailant. A supervening event may be the subject of amendment of original information or of a new charge without double jeopardy, where the charge contained in the original information was for slight physical injuries because at that time the fiscal believed that the wound suffered by the offended party would require medical attendance for a period of only 8 days. But when the preliminary investigation was conducted, the justice of the peace found that the wound would heal after a period of 30 days. The act which converted the crime into a more serious one had supervened after the filing of the original information, and this supervening event can still be the subject of amendment or of a new charge without necessarily placing the accused in double jeopardy. Impossible crimes. The commission of an impossible crime is indicative of criminal propensity or criminal tendency on the part of the actor. Such person is a potential criminal. According to positivist thinking, the community must be protected from antisocial activities, whether actual or potential, of the morbid type of man called socially dangerous person. The penalty for impossible crime is provided in Article 59 of this code. The second paragraph of Article 4 defines the so-called impossible crimes. Impossible attempts. The requisites of impossible crime: that the act performed would be an offense against persons or property, that the act was done with evil intent, that its accomplishment is inherently impossible or that the means employed is either inadequate or ineffectual, that the act performed should not constitute a violation of another provision of the RPC. Important words and phrases in paragraph 2 of Article 4, performing an act which would be an offense against persons or property. In committing an impossible crime, the offender intends to commit a felony against persons or a felony against property, and the act performed would have been an offense against the persons or property. But a felony against persons or property should not be actually committed, for otherwise you would be liable for that felony. There would be no impossible crime to speak of. Felonies against persons or felonies against property. If the act performed would be an offense against the offense other than a felony against persons or against property, there is no impossible crime. That the act was done with evil intent. Since the offender in impossible crime intended to commit an offense against persons or against property, it must be shown that the actor performed the act with evil intent. That is, he must have the intent to do an injury to another. A, who wanted to kill B, looked for him. When A saw B, he found out that B was already dead. To satisfy his grudge, A stabbed B in his breast 3 times with a knife. Is this an impossible crime? No. A knew that B was already dead when he stabbed the lifeless body. There was no evil intent on the part of A because he knew that he could not cause an injury to B. Even subjectively, he was not a criminal. Were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. In impossible crime, the act performed by the offender cannot produce an offense against persons or property because the commission of the offense against persons or against property is inherently impossible of accomplishment. Or the means employed is either A, inadequate, or B, ineffectual. Inherent impossibility of its accomplishment. This phrase means that the act intended by the offender is by its nature one of impossible accomplishment. There must be either one, legal impossibility, or two, physical impossibility of accomplishing the intended act. Examples of impossible crimes which are punishable under the RPCR: when one tries to kill another by putting in his soup a substance which he believes to be arsenic, when in fact it is common salt, and when one tries to murder a corpse. People versus Balmores would be an offense against persons. Example: A fired at B, who was lying on bed but not knowing that B was dead hours before. In crime against persons, as would have been in this case, it is necessary that the victim could be injured or killed. A dead person cannot be injured or killed. Had B been alive when he was shot and as a consequence he died, the crime committed by A would have been murder, a crime against persons. There is physical and legal impossibility in this example. Would be an offense against property. A, with intent to gain, took a watch from the pocket of B. When A had the watch in his possession, he found out that it was the watch which he had lost a week before. In other words, the watch belonged to A. Is this an impossible crime? It is believed that it may be an impossible crime. The act performed would have been theft had the watch been the property of B, but there is a legal impossibility of accomplishing it because in theft, the personal property taken must belong to another. An employee who, having known the safe combination, opens the safe in the office for the purpose of stealing money but who finds the safe empty is guilty of an impossible crime. The act performed would have been a crime of theft were it not for the inherent impossibility of its accomplishment. If there is no if there is no personal property that could be taken, it is inherently impossible to commit theft. Employment of inadequate means. Example: A, determined to poison B, uses a small quantity of arsenic by mixing it with the food being given to B, believing that the quantity employed by him is sufficient. But since in fact it is not sufficient, B is not killed. The means employed, small quantity of poison, is inadequate to kill a person, where the means employed is adequate. But where the means employed is adequate and the result expected is not produced, it is not an impossible crime but a frustrated felony. Thus, if the quantity of poison used is sufficient to kill an ordinary person but the intended victim has developed strong resistance to poison because he has been working in a mine, the crime committed is frustrated murder. Frustrated murder. Employment of ineffectual means. A tried to kill B by putting in his soup a substance which he thought was arsenic. When found it was sugar, B could not have been killed because the means employed was ineffectual. But A showed criminal tendency and hence he should be punished for it in accordance with Article 4, Paragraph 2 in relation to Article 59. A, with intent to kill B, aimed his revolver at the back of the latter. A, not knowing that it was empty, when he pressed the trigger, it did not fire. The means used by A is ineffectual. Inherent impossibility of accomplishment. A collector for a company did not remit the customer's check payment to the company but instead appropriated it for herself by depositing it to the bank account of a relative. The check was, however, dishonored. In this case, petitioner performed all the acts to consummate the crime of qualified theft, which is a crime against property. Petitioner's evil intent cannot be denied, as the mere act of unlawfully taking the check meant for the company showed her intent to gain or be unjustly enriched. Were it not for the fact that the check bounced, she would have received the face value thereof, which was not rightfully hers. Therefore, it was only due to the extraneous circumstance of the check being unfunded, a fact unknown to petitioner at the time, that prevented the crime from being produced. The thing unlawfully taken by a petitioner turned out to be absolutely worthless because the check was eventually dishonored and the company had received the cash to replace the value of said dishonored check. There can be no question that as of the time that petitioner took possession of the check meant for the company she had performed all the acts to consummate the crime of theft, had it not been impossible of accomplishment in this case. Petitioner is found guilty of an impossible crime as defined and penalized in Articles 4, Paragraph 2 and 59 of the RPC, respectively. Petitioner is sentenced to suffer the penalty of 6 months of arresto mayor and to pay costs. Jacinto versus People. Offense against persons. The accused, intending to kill a person, peppered the latter's bedroom with bullets, but since the intended victim was not home at the time, no harm came to him. He was adjudged guilty only of an impossible crime as defined and penalized in Paragraph 2, Article 4, in relation to Article 59, both of the RPC, because of the factual impossibility of producing the crime in Todd versus Court of Appeals. In a possible crime, the act performed should not constitute a violation of another provision of the code. A, who knew that B owned and always carried a watch, decided to rob B of said watch. When A met B for that purpose, B did not have the watch because he forgot to carry it with him. Thinking that B had the watch with him, A pointed his gun at him and asked for the watch. Finding that B did not have the watch, A allowed B to go without further molestation. Is this an impossible crime? It is believed that A committed attempted robbery, not impossible crime. There was intent to gain on the part of A when he decided to take the watch of B at the point of gun. The crime of robbery with intimidation of person is not produced, not because of the inherent impossibility of its accomplishment, but because of a cause or accident that B forgot to carry the watch with him, other than A's own spontaneous resistance. Article 6, Paragraph 3. Note also that A's pointing his gun at B already constituted at least a crime of grave threats under Article 282, Subdivision 2 of the RPC. This is another reason why it is not an impossible crime. Purpose of the law in punishing the impossible crime: to suppress criminal propensity or criminal tendencies objectively. The offender has not committed a felony, but subjectively he is a criminal.